Welcome to Litigation Nation. I'm your host, Jack Sanker, along with my co-host, Vanessa Watkins. Reminder, this is the podcast where we talk about the most interesting and important legal news of the past couple of weeks. For today's stories, we have an update on the class action suit related to the East Palestine, Ohio train derailment from 2023. The president of the American Bar Association says in a statement that lawyers have a duty to defend judges from attacks on their character. And Vanessa, what do you have?
Today I'm going to cover two cases out of Michigan. The first, a federal judge recently found that a local zoning regulation that would prevent wineries from hosting weddings or other gatherings is actually not an unconstitutional restriction on commercial speech or an infringement on property interests. And then also in Michigan, the parents of teenager Ethan Crumley, who is the youngster who carried out the deadliest school shooting in Michigan's history, his parents were recently sentenced to 10 to 15 years in prison for involuntary manslaughter. And this is a defining moment in the recent push to hold parents accountable for the criminal actions of their children.
All that and more, here's what you need to know. The class action suit related to the East Palestine, Ohio train derailment and chemical spill ordeal from 2023 just settled this past Monday for a gross total of $600 million. On April 9th, Norfolk Southern and the class action attorneys for the class filed a joint motion in the Northern District of Ohio, notifying the parties that they had agreed to a $600 million settlement in principle. The final terms of the deal were in the works. The class of claimants includes anyone within a 10-mile radius of the derailment for personal injury claims and then a 20-mile radius for any other claims. The settlement is being funded by Norfolk Southern mostly, along with the railcar owners, GATX Corp., Trinity Industries Leasing, and the chemical company for the vinyl chloride that was inside the tankers that spilled, and we all saw those horrible images all over social media, Oxyvinyls LP. Quoting from a Law 360 piece on the news, quote, Norfolk Southern said that it has negotiated the proposed deal as part of its ongoing efforts to make it right for the people of East Palestine and the surrounding communities in a Tuesday statement on the proposed settlement in principle. The agreement is designed to provide finality and flexibility for settlement class members, the company said. Individuals and businesses will be able to use compensation from the settlement in any manner they see fit to address potential adverse impacts from the derailment. This could include healthcare needs, medical monitoring, property restoration and diminution, and compensation for any net business loss, unquote. Good for the town and the people affected, I suppose. However, it's worth noting that the potential class size here is, I think, roughly 100,000 people. So this is about $6,000 per person.
I was just going to say, I don't do class action work, but I've always been curious about how they take these large settlements and divvy them up. You know, whose responsibility is that? And I'm sure you have to submit claims and, provide some evidence of your damages. But yeah, certainly $6,000 per person is not going to cut it here.
Yeah, so on the first part, how are these settlement funds administered? Typically, there's a trust that's set up as part of the deal that's usually being administered by the funders of the settlement, and so that those trustees will be evaluating the claims and they'll agree on the framework for how those claims get submitted. So, for example, there's a lot of funds still out there from the asbestos cases going back to like the 1980s. And if you want to submit a claim for asbestosis or mesothelioma or whatever, you typically have to provide some type of medical documentation, like a scan films that shows something in your lungs or whatever, as well as affidavits and things like that to show that you would have been exposed to this chemical in the first place. I imagine it'll be something similar like that. The one thing about the East Palestine chemical spill is that it's $600 million. It's a lot of money. But I think we are remarkably lucky that this wasn't worse than it could have been. By all accounts, at least according to the EPA, the NTSB, and I know that the private universities that are in the area, like Carnegie Mellon, I think, and a few others that have been studying this, have said, for the most part, that the water and air and all that stuff is fine. People weren't being exposed to anything higher than what they were. However, the actual like explosion itself, all of that happened in a relatively remote area of Western Ohio, and this train, if I recall, was on its way to, or it was coming from, I can't remember which, Cincinnati, and then eventually I think would have ended up here in Chicago. So had it blown up in one of those places, or in even a more densely populated suburb or whatever, you would see a lot more, damage and injury and things like that. And this, the counter or the analog to this that everyone was upset about at the time, if anyone remembers, back in 2012, there was a tanker that blew up in Quebec, which killed dozens of people, and it was a huge catastrophe. So we managed to avoid that here, and hopefully the folks in East Palestine and around there are going to be made at least somewhat whole by this settlement. But it could have been way worse. That's sort of my takeaway from this. And I, as someone I was at the NTSB hearings in East Palestine. We were involved in some of the work around this, not the class action case, but some of the other stuff. It was just apparent like how much worse this could have been. And if they had invented the tanker at the right time, it could have, been a bigger explosion, all sorts of stuff like that. So just bullet dodged here.
Mm-hmm. Well, and hopefully, I'm sure, certain people will get more than 6,000. Some people will get less. So hopefully they send the money where it's needed most.
Yeah, I mean, not everyone's going to submit a claim too. That's
right.
That's what it boils down to. I don't think I qualify for a claim for having spent 5 days there for the NTSB hearings, but this is the second episode in a row that I've theorized that I should just start joining class actions. Yeah. So in any event, I'm sure that the people in East Palestine are probably happy to get this done. I'm sure that the class action lawyers who put this together are thrilled with their fee, and Norfolk Southern hopefully has learned a lesson here, and won't let this happen again.
Okay, so my first story I'm covering today involves a lawsuit that was filed by several wineries located in the Peninsula Township in Traverse City, Michigan. Now, to provide some geographic reference, so when looking at a map, Michigan is shaped like a mitten with the thumb facing east, and Traverse City would then be located at about the tip of the ring finger. So Peninsula Township, true to its name, is a peninsula, and it juts into Grand Traverse Bay, which is part of Lake Michigan. And that peninsula is full of agricultural sites. So there are vineyards with rows of grapevines, lavender farms, nurseries, fruit stands, protected parks, all surrounded by three sides of lake. So it's really a gorgeous part of the state.
The Napa Valley of the Midwest, if you will.
Absolutely. I've actually been to Traverse City, have not been to the peninsula, but just from the pictures I saw, I mean, this is a location where you could see people wanting to host weddings and other types of events. So our plaintiff here, the wineries, they sued Peninsula Township for several restrictions and regulations that were put in place via the Peninsula Township zoning ordinance. There were regulations on advertising, what type of bar and restaurant operations they could have, prohibitions on amplified music, and then a prohibition on hosting events such as weddings and family reunions. So this case just recently got set for trial on April 29th. And on April 5th, the district judge entered a ruling on the parties' cross motions for summary judgment. So one part of the ruling addressed this ordinance prohibition on wineries using their space for weddings and receptions and other social functions for hire. The judge actually entered summary judgment against the wineries on their claim that this zoning ordinance regulated their protected commercial speech under the First Amendment. The threshold question for First Amendment claims like these is whether the ordinance regulates protected commercial speech or expressive conduct.
Is there a distinction between commercial speech and personal speech in this context?
Well, yeah. So in this case, the commercial speech has to hit certain criteria, has to be an advertisement, has to refer to a specific product or service, and then the speaker has to have an economic motivation for making it. The reason why that distinction matters is the level of scrutiny that applies.
I see. So there are different First Amendment standards.
Correct.
Okay.
Yep. So commercial speech will have a lower level of scrutiny than
Makes sense.
personal speech. Now, what the plaintiffs tried to argue here is that what they call agritourism is actually a type of modern commercial advertising. So in Michigan, the Department of Agriculture has described this term agritourism as follows. Quote, agritourism is a niche form of tourism and defines the places where agriculture and tourism connect, including any time a farming operation opens its doors to the public, inviting visitors to enjoy their products and services. Agriculture and tourism are leading economic drivers in Michigan. Agritourism offers farmers a path to diversification of their business to include value-added products and activities, which helps them better withstand things like poor weather conditions and market fluctuations, end quote. So the wineries obviously have an issue with these restrictions on their ability to bring in business, which they say if they host a wedding, for example, more patrons are going to be on their property, they're going to see their other products, and the wineries will have an increase in their sales because of that. The court, however, said that hosting weddings and other events does not automatically convert these plaintiffs' commerce-oriented activities into speech. And you can't just slap this term agritourism label onto these events. So if the court were to apply this broad term agritourism as a type of commercial speech, then essentially anytime a patron stepped foot on a wine property, that winery would be engaging in commercial speech. And according to the court, that view approaches the limitless view of speech that the Supreme Court has expressly disavowed. So because these events, weddings, reunions, baby showers, because they don't refer to a specific or discrete type of commercial transaction, but at best they really just refer to the winery and their products generally, it's not going to be a type of protected speech under the First Amendment. So regulating events does not implicate First Amendment protections. Now, the other part of the decision focused on this claim under the Takings Clause, and this part was actually a little bit more surprising to me. So the ordinance what the wineries are claiming is that the ordinance operates as a taking of their rights to operate their restaurants and keep certain hours of operation, playing music for their guests, and use of their licenses under the Michigan Liquor Control Code. So the Fifth Amendment's taking clause protects private citizens from the government taking their property for public use without just compensation. And one example of a taking is when a government invokes a regulation that denies a property owner the full use of their property.
There you go.
So I think this was probably their best argument that they put forth. But once again, the court found for the township, it said there is no precedent for recognizing that a liquor license is a property interest protected by the Takings Clause.
So the having a license is not a property interest for purposes of the Takings Clause. That's interesting. I mean, I have a law license, right? Mm-hmm. You have a law license. Doctors have their medical licenses. I suppose this would imply that those licenses could be revoked without due process.
I don't know if I would go that far in a reading of this. And it's also, it's hard to compare apples to oranges because obviously a liquor license is going to have certain restrictions on it anyway. I think in Michigan there are limits on when you can actually sell alcohol in the state. And
obviously you can't sell to minors.
Right. So I think the government has allowed restrictions on that license and apparently is finding that further restrictions on it or restrictions that may affect the ability to use that license. But it's different because here it's you can't play music to a certain extent. Okay, well, does that limit your patronage that are
probably
you drinking your liquor or whatever? I mean, yes, but the court's not willing to take it that far.
Yeah, and then also there's the fact that the local municipality here is regulating the state-issued liquor license effectively.
setting more restrictions locally, yes, than they would at a state level. And of course, they're looking at it from community standards. This is a fairly small community, and so they want to make sure that there aren't any nuisances from noise or traffic, and so they are, I guess, protecting the locals from having to deal with whatever these wineries opening themselves up to 200-person events could bring.
I guess the flip side of this is probably probably ridiculous. Like if zoning regulations for these types of things were found to be in violation of either the state or federal constitution, how does that play out, like in a crowded city, for example? Mm-hmm. Like how of a sudden how does the building code get enforced and everything else? So I guess it's not that surprising when you think about it in the macro level. Yeah,
I think though it was an interesting argument to push
from the First Amendment perspective, for sure.
Yeah. So essentially, this ruling just significantly limited what issues are going to be heard at trial. The wineries are still going to be able to bring their case on merchandising and advertising rules, but these issues of commercial speech and the takings clause, they got thrown out. So we'll see what happens with this.
Not exactly a free speech story, but kind of. The president of the American Bar Association said in a statement just this past Monday here in Chicago, she warned of the threats and rhetorical and even serious physical threats that have been made to judges over the past couple of years, which of course have been a real problem, and in and of themselves, it should go without saying, are abhorrent. But also talks a lot about the assault on the character of judges themselves. And I'll read a portion of her statement to you. Quote, "Our courts and judges are under attack. Serious threats against judges have doubled since 2019, with 457 serious threats targeting federal judges across the country. In 2023, national leaders and private citizens are making false statements and scurrilous accusations against judges for partisan and personal gain. These attacks are no idle matter. Often they involve physical threats of harm or death, not only to the judges, but to their families and staff." I'll take a pause real quick right there and say all of that should go without saying is well beyond the pale and not acceptable in polite society or any serious society at all. But it's kind of the next bit here that is somewhat interesting for me. Going back to the quote, "Threats against the very individuals we have appointed or elected to administer our judicial system and the rule of law are not only wrong, they also threaten the very fabric of our democracy, judicial independence, and the rule of law. All lawyers are bound by ethical rules based on the ABA model rules of professional conduct. These rules prohibit lawyers from making false statements about the qualifications or integrity of a judge. Based on these rules and to maintain the fair and independent administration of justice, lawyers are encouraged to defend judges and courts that are unjustly criticized." Unquote. So it's that last bit that really jumped out to me. She's not saying the ABA is recommending that you jump on Facebook and get into arguments with your aunts and uncles about the Supreme Court, right? But I think she is encouraging attorneys and members of the bar to police the speech around criticism of judges and judicial decisions. And I get generally what she's saying here, which is the crank theories about whatever it is you want to say, the election or whatever, we should probably pipe up and go and say something about that. But let's take a pause on that for a minute. I mean, there are and have been over recent years valid criticisms, I think, voiced at both, the federal circuit court judge level, but especially at the Supreme Court level, of people criticizing what they perceive as impropriety, to use a polite word, but some people would say, outright corruption. And this is a bit of a, from the ABA here, to encourage members of the bar to kind of like stick up and I guess maybe deflect or defend certain things like this. It struck a weird tone for me. given, the standards of free speech in this country and everything else. Later, I'm going to read again from the remainder of the statement here. Quote, bar associations have a special responsibility to ensure that the public holds the judiciary to the highest esteem. Parenthetical, I would say that judges have a special responsibility to ensure the public holds them to the highest esteem.
I would agree with that.
Yeah.
I mean, I think I see it from both sides, I guess, and it's hard for me to defend what the Supreme Court is doing, but I can take this what the ABA president is telling us. I can take it on a more local level, and it did cause me. So she did email this out to anyone who's a member of the ABA who signed up for emails, because I did get it by email too. And it did make me think a little bit about, as lawyers, the first thing you do when you get a case, you research the opposing counsel, you research the judge. And oftentimes I do send reports to my clients about the judges. What kind of cases have they had before them? How did they come down? Is there any patterns? Like, what should we be aware of?
And let's not mince words here. Like, when we say we do research on the judge, we'll oftentimes advise our clients, this judge doesn't know anything about this type of law.
Right.
Or this judge is so plaintiff friendly or defense friendly that depending on the claim that's in front of them, you're never going to get a fair shake.
Yeah.
That's often our candid assessments. And I'm sure that I hope that there are listeners here nodding along, but maybe some of them are shocked. It isn't shocking to anyone who litigates.
Right.
That I think I could speak for all of us when I say that.
But I think what I took, though, maybe from this warning that she put out, is that sometimes we have to be aware of who our clients are or who our audience is when we're saying these things.
Yeah.
It's one thing for us to come to our own conclusions, but maybe that's a takeaway for us on a local level of, maybe you need to pay a little bit more attention to how you word these things and show a little bit more respect for the judges, because your clients aren't going to forget that when that bad ruling comes down, when your motion gets denied or whatever the case may be. Oh, yeah, I remember you told me from the beginning that this judge wasn't going to rule for us. And then, it becomes more of, well, maybe that ruling did have some merit to it. And,
oh, yeah. Well, and there's also, to your point, being aware of the audience, you have to be aware of how people are going to perceive this. If every lawyer in your jurisdiction is saying, man, that judge really stinks, for XYZ reason, there could be someone that hears that and is like, wow, that judge is bad. I should threaten their family.
Right.
And it's like, so maybe you don't complain so loudly, because you have to understand that there are a lot of crazy people out there who's going to hear this stuff and not have any context to put it in, right? Like, so if our context, I'm assigned to a certain judge and I say, listen, this judge has, in my opinion, certain biases or whatever. That's in the context of like every judge in their jurisdiction on these narrow issues. I think it goes without saying that if you're a judge who has either been elected or appointed, there's a baseline level of competency that you are expected to have and that every judge I've ever practiced before does have. It's in the margins where you can make these judgment calls or whatever. But someone who's not in the industry or doesn't understand that and thinks, well, just because this federal circuit court judge was appointed by Barack Obama or Donald Trump, they will always decide the issues in favor of those two political agendas. And that's just like, that's never the case. And even if you look at those judges, they don't rule that way, like often. Yeah. On a particular case, they may or may not, but it just doesn't work that way. Mm-hmm. By and large, the judges are trying to like be public servants and do a good job here. But the tone of this whole thing did kind of strike me as it should be illegal to make fun of us. That's you're not allowed to make fun of us, and if you overhear anyone making fun of us, you should tell them to stop.
Oh gosh, I don't know that I took it that way.
Let me read this last part.
Okay.
Quote, every one of us must stand up for our judges and their staffs and engage in the civic education needed to help our public understand how our courts work, the crucial role of the independent judges in a functioning democracy, and why their integrity must be defended and their safety ensured. Unquote. Safety ensured, yes. Yeah. Integrity defended, yes. Independent judiciary, yes, of course. civic education needed to help the public understand how our courts work. I mean, that's your job, man. You're the public employee, right? Like, I'm sorry, but and I understand as members of the bar, we do have obligations to the public at large, and I think that everyone in their heart of hearts tries to put on a good impression for the public and how the profession works. But if the judiciary and the administration of justice is like shrouded in this like kind of cloak of Latin phrases, and the judge literally wears a cape, and you don't have, I mean, if you've ever seen a pro se litigant in court, they are so disadvantaged to the point where they're basically in another country with people speaking a different language. And so that aspect of this stuff, I think, is the public's fault, not the private members of the Bar Association. And it just struck a weird tone for me to be like, listen, you all need to make sure that no one's making fun of our judges. Mm-hmm. And to which I would say, not the judges, but, from the top down, if you're worried about that, I mean, maybe those people who are getting criticized, again, not death threats, not things like that, but the criticism, should be doing a better job understanding how that process works. And I think one of the most shocking things from the Dobbs opinion, for example, when that got leaked, and was for a moment people actually thought about how the Supreme Court must decide these. And mm-hmm. no one thinks about that. They think it's just a black box that arguments and briefs go into and then decisions come out of. Yeah. But the Dobbs decision, which showed there's drafts, there's negotiations among the 9 justices. They are pitching ideas to each other. They are arguing to each other. Mm-hmm. They are recruiting each other to sign on to different opinions and everything. And I think people, when they stop and thought about that for a minute, they're like, oh my God, I don't know how this stuff even works. Yeah. I don't even know who these people are or how this process, there's no transparency at all. And of course, there's not. And I'm not saying there should be. But if there's no transparency at all and people don't like the outcome, people are going to complain. And the crazy ones among us are going to come up with conspiracies to explain it. So I guess that's my 2 cents of just saying I think the ABA president here has the right idea. But I think, I don't think it's my job.
It is interesting how I didn't think to really talk to any of my colleagues about it, but how we probably all interpreted this in a little bit of different ways. I just think our system has come under a microscope. President Trump made it a point to appoint as many federal judges as possible, and I think that caused probably some people to start paying attention. And maybe people didn't realize that in certain cases, judges are appointed, that federal judges are appointed, and also certain state and local judges are appointed, which is different. Here in Cook County, our judges run for election. They have to go out and run an election and meet the people. And I actually favor that because, it gives you a chance to actually meet the candidates. And but I can see the other side of that too, where, you have the plaintiffs' bar that are putting on events for a judge, or, judges need to be careful. They can very easily create this type of, misconception, I guess, and that's only been furthered too by the investigations into Justice Thomas, taking these lavish vacations and stuff, and then you start to wonder, all right, well, maybe that's why he decided that case that way.
And I'm not even necessarily, signing on to those allegations, but we covered, it was an episode 40, a while back. There's a federal judge who was under a pretty a lot of scrutiny for the judge's competency. And this was a judge who, if I recall, was in her late 70s or early 80s and was having signs of cognitive issues and things like that. And penned a really, really strong objection to this, basically saying, how dare you investigate me? Because, I'm a public servant. I've given my life to this and all those things. And, in no other context would that be appropriate to say, again, like how it should be illegal to make fun of me. You shouldn't be allowed to question me. And like I get and I do understand, and I think it's important that judges are occupy a special role in society, and that the presumptions of integrity and the presumptions of good intentions and the presumptions of competency come with the robe, and for most of the time for good reason. But like when you have something like Clarence Thomas thing, or whatever political persuasion you are, Justice Sotomayor was it seems like at least was when she would do speaking engagement in universities, it was like contingent on them buying like a bunch of her books, right? So like that's a kickback, and however you want to like, whichever side of this you think you're on, the broader that your lens is at it, you're like, everyone else would get in trouble for that. And the fact that like they don't is one thing. And the fact that you're having people like immensely powerful people politically, like the president of the ABA saying, hey, don't complain too loudly about this, does make you feel like you're going crazy. And it's just one of those things where, I don't know, there's a large element of people that are taking this all the wrong way and way too far and should do a better job educating themselves as citizens about how this stuff works. But there's also a big contingent of the problem here that I think is, if you are worried about people's misconceptions about how broadly, the judiciary works, get yourself out there and educate the people. Don't blame me.
I hear you. All right, now taking us to, unfortunately, a little bit of a darker story. This is the school shooting that occurred back in November 30th of 2021, where 15-year-old Ethan Crumley, he actually committed the deadliest school shooting in Michigan's history, killing 4 students, wounding 6 students, and also a teacher. Now, the recent story is that both of his parents were just sentenced to 10 to 15 years for involuntary manslaughter, which is a monumental turn in these school shooting cases for the fact that the parents were held individually liable for the acts of their child. Now, soon after this shooting occurred, the Oakland County prosecutor on the case, Karen McDonald, she actually delivered the shocking news that she was pursuing charges against the parents only a few days after the shooting. And just to give you a little bit of an idea of the landscape, so Oxford, Michigan, politically speaking, is largely purple. There were many gun rights advocates in the town that did not like the potential for a new precedent being set that would put additional responsibilities on gun owners. So in Michigan, with very limited exceptions, minors are not allowed to possess guns, but there is no Michigan law that would require owners to keep guns locked and away from kids. So by comparison, I believe it's now 23 states plus Washington, D.C. that have some form of a secure storage law. And I mention that only because a 2019 assessment by the U.S. Department of Homeland Security found that guns came from the home of a parent or close relative in 76% of school attacks where firearms were used. And in about half of those, the firearms were easily accessible. So all of this background certainly played a major role in the prosecutor's decision, and not to mention the sad reality that the U.S. endures the most mass shootings worldwide. So fast forward to this case. Ethan Crumley pleaded guilty in October of 2022 to 24 charges, which included first-degree murder and terrorism causing death. And despite being 15, under Michigan law, the judge was able to determine through evidentiary hearings whether he, as a minor, should be eligible for an adult sentence. So at this point in Ethan's case, while his defense team attempted to get him tried as a minor, there was a clear conflict that emerged between him and his parents. Ethan's attorney said that Ethan was deeply neglected by his parents and put forth evidence from a psychologist that described Ethan as a feral child. Now, despite these,
his attorney took that position.
His attorney hired a psychologist who did an assessment, and that's how they described him.
Ooh.
So, despite best efforts, the court found that Ethan's possibility of rehabilitation was slim, that the crime didn't bear the hallmarks of youth, and that Ethan continues to be obsessed with violence even while in jail. So, they ended up trying him as an adult, and in December of 2022, Ethan was sentenced to life in prison without parole, which is the automatic sentence for adults charged with first-degree murder. And this is actually the harshest sentence in Michigan because it does not have the death penalty. So now, despite the fact that Ethan was tried as an adult, his parents, they still continued these charges against them for involuntary manslaughter. Now, in the past, there have been situations where parents have been held responsible for the acts of their children, and I'll get into that in a little bit more detail. But that's why this case is distinguishable, because they found that Ethan was essentially emancipated from his parents in the eyes of the sentencing and held him.
But the parents were nonetheless responsible for.
Right. The state still continued to try to press these charges against them. So obviously a lot came out in Ethan's sentencing hearing, a lot of evidence that was then also used in the case against the parents. The defense for the parents, and they were tried separately, which actually created another conflict because there were a lot of witnesses who described the mom as being this tough, rough-edged, the type of person that doesn't believe in therapy, wasn't going to take seriously her son's issues of mental health, whereas the dad was a little bit, they almost described him as like meek, friendly, meek. The mom wore the pants is the picture that started to emerge. So they did have to try them separately, and I think probably the prosecutor's hope was that maybe the dad would throw the mom under the bus a little bit.
Yeah. I'm assuming that the mom and dad were at least involved in coordinating the defense of their kid, or because if you think about it, defending the child here would involve painting a picture of he is a minor. It should be tried as a child because the parents had I guess some responsibility control or whatever that you would prove there over it, which would be in conflict with how you would defend the parents, right? If you were the parents' defense attorney, you would say that the kid was a bad egg and it wasn't our fault.
Yeah, that's a good point. There were conflicts spread all across this case, and which is actually kind of sad, because obviously the family is going to be broken up in general as a result of a tragedy like this, but yeah, the way that the prosecutions came out, certainly pinned them against each other even more.
Yeah.
And I did read somewhere this mom was not very savvy about how putting stuff on social media could come back to bite her, or even texting, putting anything in text in general.
People need to stop doing that.
Oh my gosh, it's like, have you not watched the first 48? Like everything comes out. But yeah, I think there was a text message that she had sent to a friend. She immediately went into hiding, her and her husband. She texted something like, "Ethan's on his own now. I need to protect myself."
Okay.
So yeah, it's there was a lot of bad evidence that came out against the parents. So, in this case, it was probably the right case for pursuing this novel type of prosecution, just because of how really sad this evidence is. So, leading up to the shooting, how the gun came into play was it was actually a early Christmas present from the parents. The father bought it with his son with him, and the prosecutor argued that they purchased this at a time where there were clear signs that their son's mental health was deteriorating and that he was potentially violent. So the gun was purchased 4 days before the shooting. The mother posted pictures and images of her and her son at the shooting range. But even prior to that, so leading up to his 15th birthday, Ethan began texting his mother about his paranoia. He was saying that he was hearing things. He thought people were in the house. He was scared to be alone. All of these texts were introduced at the parents' trial, as well as Ethan's journal, where he wrote about getting no help for his mental health problems. Quote, I want help, but my parents don't listen to me, so I can't get any help. End quote. He wrote about his desire to watch students suffer, the likelihood that he would spend his life in prison. So, it's one of those things where I know as a kid, I was like, Mom, don't read my diary. But now as a parent, I'm like, I'm probably going to be checking in on things, And
well, because there's also, I know, evidence. I mean, I know that the school was involved at one point or another. Because he was like.
Well, yeah, let me get to that part.
Yeah.
That's actually the worst
part. The parents
part.
were not in the dark here, is I think the point.
Yeah, and after I say this, you'll understand. I'm wondering why there wasn't some liability potentially on the school as well.
Mm-hmm.
But so the day of the shooting, Ethan made a ghastly drawing of a gun and a wounded man on his math assignment, and then he added the phrase, "The thoughts won't stop. Help me. My life is useless." So obviously, the teacher took it seriously. The parents were called to the school for a meeting, and the school pushed them to take Ethan home, but they didn't demand it. The school counselor was concerned that Ethan was having suicidal ideations, and they told the parents they need to seek help for him within 48 hours. But the parents refused to take him home. And the school couldn't force it, and they said, maybe being in a school setting is the best thing for him at this time. So they sent him back to class. They didn't check his locker. They didn't check his bag. The parents also did not disclose that they had just purchased him a handgun 5 days earlier.
Just bonkers.
Yeah. So
to not be like, you know what, is the handgun still in the drawer?
Maybe let's take a pause, go home and check. Just,
I mean, of course, all of this is 2020 retrospect.
Right.
But
yeah. So he returned to class, and then later that afternoon walked out of a bathroom with the gun and began firing. Investigators found an empty gun case and empty ammunition box on the parents' bed, as well as a cable that could have been used to lock the gun, but it was still in its package unopened. So.
Yeah. That's brutal. I am interested. And I would be surprised if the school is not subject to civil litigation here.
Yeah.
I mean, they're going to have.
And I didn't research it, so it just kind of was a thought that popped into my head. So it could be.
Your instinct here is correct. That well, wait a second. You knew or should have known that this kid posed a threat. The evidence of that is that you called his parents in to tell them exactly that, and you didn't do X, Y, Z to prevent this shooting, such as do a routine locker or backpack check, which they do all the time for obviously for drugs and things like that. But when I was in middle school, if you were suspected of having Pokemon cards, they would tear through your locker because you weren't allowed to have Pokemon cards in school. So the point is that schools have this capacity and do it all the time.
Right.
So I think that they're it's interesting. I don't think that the school ought to be subject to criminal liability. Probably not. And I don't think that they could be. But I wouldn't be surprised if there may already be civil actions pending involving the school.
Yeah. I mean, my mom she was a guidance counselor at my high school for 35 years. There were definitely times where a student, came in and had some type of, showed signs of violence, and she shut down her whole day and spent it with that kid, clear the schedule. This is my priority. Oh, yeah.
Well, I went to a metal detector school, so all the guns got clocked at the door. You think I'm joking, but yeah, they did. But the Pokemon cards were the big thing. I say that as a bit as a joke, but schools routinely intervene in these scenarios over what they deem contraband, which is, I think, like drugs, but also just like things that, like it used to be you couldn't have a cell phone, right? And they would be like, oh, you have a cell phone in your locker. Like, we have to take that till the end of the day or whatever. Stuff like that would get you in trouble. So it does seem like they've dropped the ball here.
Yeah. Well, so earlier this year in January, the mother stood trial. She ended up being found guilty on all 4 counts of involuntary manslaughter after the jury deliberated for just 11 hours. And then in March, the father had a week-long trial, and he was also found guilty on all 4 counts of involuntary manslaughter. So the 15 years is the max sentence for that crime in Michigan, and the prosecutor asked for 10 to 15 years for both of the parents. And then on April 9th, the judge sentenced both parents each 10 to 15 years in prison. So, certainly there was no precedent for this case. The Crumleys were the first parents to be held directly responsible for a school shooting carried out by their child, which essentially turns on its head the bedrock legal principle that people cannot be held responsible for the actions of others. Now, I found a article in the 74, and they interviewed Ikaw Yanka, a University of Michigan law professor. He voiced some serious concerns about this, saying that going forward, if we have other parents that are being charged in connection with shootings that are acted out by their children, then this Crumley conviction may make them more likely to accept a plea deal behind closed doors. So he said, quote,
or more likely to lock their guns up.
Oh, well, yeah. I mean, that's the other side of it. So this is just giving, the side of it, I guess, more from the legal perspective of how prosecutors could start to use this as a sword. So what he said was, prosecutors will be tempted to use this power in ways that we don't see. A prosecutor is going to sit across from a parent when people are crying out for somebody to be held accountable, and the prosecutor is going to be able to say, I'm offering you 3 to 5 years in prison, but if you don't take this deal, I will prosecute for 15 years. Evan Bernick, a professor at Northern Illinois University College of Law, had similar concerns that he voiced to Al Jazeera. He said, there's a saying, hard cases make bad law, which means that there's always an initial horrifying case that's used to justify the expansion of criminal law. Then there are a whole class of cases that you don't see, that you don't get national attention, end quote. And then he talked about how he could see that this case could be used against the marginalized communities. Those parents who are working 3 jobs, trying to make ends meet, and then their kid does, it doesn't need to be homicide, but, does something criminal. Right. They weren't supervising them because they're, trying to put food on the table, and now, the community is going to cry out, and so the prosecutor is going to say, hey, take this plea deal.
I think the fact that this was manslaughter conviction, right?
Involuntary manslaughter.
Yeah, involuntary manslaughter. That's so. I mean, that's so interesting. I think if the state of Michigan, if you're listening, Michigan, it could actually like narrow this in a way that still incentivizes parents to take better care of their firearms, because I think taking a broad brush like involuntary manslaughter and then applying it to the facts of like this case, but then opening it up to other things down the road, as you mentioned, does kick the door open for prosecutorial misuse. Mm-hmm. But if the state of Michigan has a compelling interest in preventing school shootings or whatever, or just preventing any shootings, there is, the argument that gun safety advocates have been making for decades, which is registration of the firearm. And if your firearm, and unless we'll give broad exceptions to the rule here, but if your firearm is used to commit a crime, there's a statutory violation of that, and maybe it's prison time, maybe it's fine or probation or whatever. Mm-hmm. And unless it's like stolen from you or there's some excuse as to how it ended up in someone else's hands. But I think something like that applied to these facts here would make a lot more sense, and then also prevent prosecutors from having the discretion to heap criminal charges on the parents who maybe don't deserve it. Mm-hmm. I'm not saying these parents in this case didn't, by the way.
Right, but it's like that professor said, that, you take these egregious cases but they do set the precedent going forward for cases that maybe, the evidence isn't so glaring that the parents dropped the ball. Now, there are parental responsibility laws nationwide, and those do impose civil or criminal liability on adults under the premise that their failures to take control as parents led to their kids' bad acts. However, these laws are generally premised on the idea that the child who committed the crime is unemancipated. So it's kind of like a vicarious liability argument.
An agency type thing.
Yeah. But so that's why this case is distinct, because Ethan was charged and tried as an adult. So the law considered him a legal agent responsible for his own actions, and yet still found that the parents, were a proximate cause of these deaths.
Yeah, which is a bit tenuous the more you think about it, even if you agree or are agreeable to the outcome here.
On the other end of the spectrum, certainly for gun control advocates and the parents of those children who have been killed in their classrooms, this landmark trial outcome was certainly welcomed. Organizations such as Everytown for Gun Safety say that verdicts like these could have a deterrent effect, help prevent future mass shootings, serving a warning about safely securing guns, essentially all the things that you said. But, even in the wake of these new laws that are coming out, we don't have the evidence about whether they're actually preventing crimes, so hopefully there will start to be some research on those and what the effects are, especially in the wake of this decision. And I'm sure, it's going to continue to have effects rippling through our system. So
what's interesting is that giving the prosecutors broad discretion to just tack on criminal charges to parents or whatever is actually like less burdensome from a Second Amendment perspective on the kind of 2A rights that those people are so concerned about, because there's no prior restraint on purchase or added regulations to guns or gun purchases or ownership or whatever. It's just added consequences for when things go wrong, which ought to be self-regulating, but that's not exactly how everyone works. So it'll be interesting to see. I have not seen whether this has been kind of played out in the various media spheres as either good or bad for gun owners and gun rights advocacy people who tend to take positions on these cases. I just haven't seen those groups being like, this is good or bad for us. But it is less burdensome to give the prosecutors discretion to do this if you want to regulate this type of thing, but is bad for all the other reasons we talked about.
Yeah, I mean, I think it's a continuing problem in our country. I think we're looking for, obviously, ways to deter this type of violence, but also, new people to blame. I don't know. I mean, I know you covered, I think it was in episode 11, Sandy Hook, and then episode 26, the Uvalde tragedies. But I think those discussions were focus more on the gun manufacturers. But, there have been no consequences to that end of things. So, I guess this is just the next attempt to try to curtail this. So that's our show. Thank you for listening. Remember, you can find us, Litigation Nation, wherever you get your podcasts, Apple, Spotify, YouTube. Please subscribe, like, share, leave us some comments. Let us know what you're interested in, what you want to hear more about, and we'll keep bringing you the news.